Ms. Bondi, good morning.
Good morning.
What became of the $50,000 in cash that the FBI paid to Mr. Homan in a paper bag, evidently?
The day before the Department of Justice arraigned a former FBI director for lying to Congress, the Attorney General of the United States sat in that very chair and made demonstrably false statements to the same committee. If truth doesn't matter equally for everyone, it doesn't matter at all. Here's the second critical issue that needs to be addressed, and this goes back directly to the ranking member's comments about what happened yesterday in this committee. To Senator Whitehouse, yesterday was an awful day in the entire history of this committee. It set new low after new low after new low in terms of standards, honesty, and accountability. Whitehouse made clear he wasn't going to talk about all of the new lows that were reached. He was going to focus on one in particular, one that cuts to the very heart of whether this institution still functions as a check on executive power. And that particular issue is whether anybody in that room noticed the irony, the absolutely stunning irony, that the day before the United States Department of Justice arraigned a former FBI director for allegedly making untruthful statements to this very committee, the Attorney General of the United States sat right there in that witness chair and made untruthful statements to this committee. Senator Sheldon Whitehouse didn't just raise vague concerns or express general dissatisfaction with testimony. He laid out step by step, with specific examples and verifiable evidence, how Attorney General Pam Bondi and FBI Director Kash Patel delivered statements that conflict directly with verifiable public records that anyone can access and check. This wasn't speculation about possible inaccuracies. This wasn't political spin or partisan interpretation of ambiguous statements. This was a systematic breakdown of accountability at the highest levels of the Justice Department, the very institution charged with upholding truth and law. And these weren't maybe untruthful statements where reasonable people could disagree about interpretation. This wasn't a question of nuance or shading or context. Attorney General Bondi made specific allegations about the ranking member and about Whitehouse himself having received political contributions from what she characterized as an Epstein close confidant. She made these allegations in sworn testimony before the committee. Well, guess what? That's actually checkable. There's a thing called the Federal Election Commission. The Federal Election Commission maintains a public website that tracks all campaign contributions to members of Congress. An intern at the Department of Justice, literally a college student working a summer job, could have checked in about 2 minutes to see whether the allegation, and Whitehouse said he'd limit this to himself personally, whether he had received campaign contributions from this individual that Bondi named. That intern would have discovered immediately that the allegation was false, and it's not a maybe answer where different people could interpret the data differently. It's a yes or no question. Did Whitehouse receive contributions from this person, or didn't he? And there's an unimpeachable public record maintained by the federal government that shows definitively that what Bondi said while sitting right there under oath was not true.
Senator, as Deputy Attorney General Todd Blanche recently stated, the investigation of Mr. Homan was subjected to a full review by the FBI, agents, and DOJ prosecutors. They found no credible evidence of any wrongdoing.
And that was not my question. My question was, what became of the $50,000 in cash that the FBI delivered, evidently in a paper bag, to Mr. Homan?
When the Attorney General makes allegations that can be disproven with a 2-minute FEC search, and the FBI Director claims court orders exist that judges say never existed, we're not seeing mistakes. We're seeing a deliberate strategy to mislead Congress. If we are going to care about untruthful statements made by officials from the Department of Justice and the FBI to this committee, if we're going to treat that as a serious matter worthy of criminal charges, as we saw with the former FBI director, then let's not have this be yet another area where there are completely different rules for one party than for the other party. The standards have to be consistent or they're meaningless. And just by the way, on that very subject of false statements, the other thing that Attorney General Bondi did while sitting right there in that witness chair was to strip all cover away from the untruthful statements that had been made to this committee by the current FBI director. Everyone on this committee heard FBI Director Patel testify here. He stated clearly that he couldn't tell senators about his grand jury testimony in the Mar-a-Lago classified documents case, the case where he first invoked his Fifth Amendment right against self-incrimination, then received immunity from prosecution, and then testified before the grand jury. He couldn't tell the committee what he testified to, Patel claimed, because the Department of Justice had sealed the testimony and because there was a court order barring him from discussing it. And he didn't just make vague claims about restrictions. He actually identified which specific judge had issued this supposed order, naming the chief judge of the D.C. Federal District Court. Well, guess what? We know that since Patel made those statements to this committee, the chief judge of the Federal District Court has publicly stated that what Patel claimed was not true. The judge said specifically and unambiguously that nothing prevented Director Patel from discussing his grand jury testimony. There was no court order. The restrictions Patel claimed existed simply did not exist. And yesterday, during Bondi's testimony, White House noted he wasn't entirely sure what would happen, but the Attorney General had the perfect opportunity to say, "You're right, Senator, we did seal the testimony in that matter. The Department of Justice did seal that grand jury testimony, and therefore Patel's statement was true." Not about the court order, which clearly didn't exist, but at least it was sealed by the Department of Justice, so he had some basis for claiming he couldn't discuss it. Bondi didn't say that. She didn't confirm that DOJ had sealed anything. So now both of Patel's claims, both his testimony that the DOJ had sealed his testimony and his testimony that there was a court order barring his testimony, are demonstrably false statements made to this committee. These aren't matters of opinion or interpretation. They're factual claims that can be verified or disproven, and they've been disproven. And then when Patel came back for subsequent testimony and senators challenged him on those false statements, when they pressed him to explain the discrepancies, his second wave of false statements was to say, "I'm not going to answer any of those questions because my transcript of the grand jury testimony, I've worked with the DOJ to see that it is publicly released." Well, either a transcript has been publicly released or it hasn't. It's a very simple binary distinction, yes or no. Has it been released to the public or not? And we all know, because we can check, because public records are by definition public, that it has not in fact been publicly released anywhere. There is no publicly available transcript of Patel's grand jury testimony, despite his claims. And when senators asked about that directly from Attorney General Bondi, when they gave her the opportunity to confirm Patel's claim, she left him high and dry. She refused to say that anything had been publicly released. She refused to confirm that there was any publicly released transcript of Patel's grand jury testimony.
They did not deliver $50,000 in cash to Mr. Homan?
Senator, as recently stated, the investigation of Mr. Homan was subjected to a full review
different question.
by the FBI agents,
That's a
by
different
Department
question.
of Justice prosecutors. They found no evidence of wrongdoing.
That's a different question.
A former FBI director faces criminal charges for lying to Congress, while the current Attorney General and FBI director make false statements without correction or consequence. When equal justice becomes selective justice, the rule of law dies. So yesterday's hearing stands in really stark contrast to what happened the day before. Actually, White House corrected himself. The day before yesterday stands in really stark contrast to yesterday. The day before yesterday, an FBI director, a former director who no longer holds power, was arraigned for making a false statement to this committee. That's being treated as a serious crime worthy of prosecution. The day before that arraignment, the Attorney General of the United States made what White House characterized as arguably even falser statements. Statements that are more clearly and demonstrably untrue than what the former director is being charged with. We'll see how the other criminal case turns out in court. And Bondi left the current FBI director completely exposed on his multiple false statements. She didn't back up his claim that his grand jury testimony in the Mar-a-Lago case had been sealed by the department. She didn't support his claim that it was under court order not to be released. She didn't confirm his claim that it had since been publicly released as a transcript. On all three factual assertions that Patel made to this committee, assertions that can be verified or disproven through public records and judicial statements, Bondi provided no support, effectively confirming they were false. White House posed the fundamental question. I don't know if this committee is going to take itself seriously enough to treat false statements to this committee as serious matters irrespective of who made them, regardless of their party affiliation or current position of power. But the contrast is really stark, really undeniable when you lay out the facts side by side. What Senator Sheldon Whitehouse did in that moment wasn't just another round of partisan questioning or political theater. It was a rare moment where someone stopped the entire performance and said, "Enough. The truth matters. No more games, no more double standards, no more looking the other way when powerful people lie." And that intervention is significant because it speaks directly to the health of our democratic institutions and the fragility of public trust in government. White House wasn't improvising or speculating or making educated guesses. He pointed to specific examples where the Attorney General's statements do not match public records that anyone can verify. He identified where the FBI director's explanations directly contradict what federal judges themselves have stated on the record. That is not a minor discrepancy or a difference of interpretation. It's a fundamental breach in how the justice system is supposed to function when truth and facts still matter. We often talk about checks and balances in abstract terms, but this is exactly what that phrase means in concrete practice. It means Congress asking hard questions about whether the truth is being protected or whether those in power are manipulating it for political advantage. It means holding officials accountable when their statements don't match reality. White House highlighted that the Attorney General's claim about campaign contributions could have been verified with a 2-minute search on the Federal Election Commission website. That basic fact-checking wasn't done before making the allegation. Or worse, the truth was discovered and then ignored because the false allegation served a political purpose. And then there's the issue of the FBI director's grand jury testimony, which reveals an even more troubling pattern. When a top law enforcement official tells Congress under oath that he cannot discuss testimony due to a court order, and then the chief judge later confirms publicly that no such order exists and never existed, we have a structural problem that goes beyond one person's credibility. It raises the unavoidable question, is the Justice Department genuinely misinformed about basic legal facts, or is it intentionally misleading Congress? Either possibility is dangerous for different reasons, but both undermine the oversight function that Congress is constitutionally required to perform. But the deeper issue that White House exposed with surgical precision is the erosion of equal standards in our justice system. He pointed out that a former FBI director is being criminally charged for allegedly lying to Congress about matters under investigation, while sitting officials at the highest levels delivered statements that contradict verifiable facts, that contradict federal judges, that contradict public records, without any correction, without any clarification, without any acknowledgement of error, and certainly without any consequence. That discrepancy undermines the most basic principle of American justice, the foundational idea that no one is above the law regardless of position or power. This is where we need to understand the larger stakes beyond this particular hearing. When leaders in the Justice Department refuse to correct false statements, when they allow those falsehoods to stand unchallenged in the official record,
I want to be clear about
they weaken the entire oversight system that prevents abuse of power. Oversight isn't just about catching wrongdoing after it happens. It's about preventing wrongdoing by ensuring transparency and accountability. If the executive branch can give misleading testimony to Congress without consequences, without even being required to correct the record, then the legislative branch loses its ability to investigate abuse, enforce the law, or act as a meaningful constitutional safeguard against executive overreach. White House also raised serious concerns about improper access to Epstein-related documents by White House staff, which would violate long-standing DOJ White House contact policies designed to prevent political interference in sensitive investigations. Those policies date back decades through both Democratic and Republican administrations and exist specifically to stop the White House from influencing ongoing cases for political purposes. If those rules were ignored or deliberately bypassed, it raises the very real risk of political manipulation of investigations that should be conducted independently based solely on facts and law. There's a human element here, too, that extends beyond Washington politics. When public trust collapses in institutions, when people stop believing that the legal system operates fairly and honestly, the consequences ripple through society. People stop believing that institutions can protect them from abuse. They stop believing the legal system is fair or that truth matters in official proceedings. And that breakdown of trust is exactly what authoritarian leaders throughout history have relied upon, sowing chaos, undermining accountability, attacking objective truth, and turning institutions like the Justice Department into arms of political power rather than neutral enforcers of law. White House's message was simple but powerful in its implications. If honesty becomes optional for the powerful, if truth in testimony is treated as a suggestion rather than an obligation, then democracy itself becomes optional. If the Attorney General and FBI Director cannot or will not deliver truthful, verifiable information to Congress during oversight hearings, then Congress cannot do its constitutionally mandated job of checking executive power, and the public loses its most essential protection against tyranny: meaningful oversight of those who wield government authority. This moment should matter to every person watching, regardless of party affiliation or political ideology. Because if truthfulness in testimony is allowed to slip, if we accept different standards for different people based on their current position or political usefulness, it won't just hurt political opponents in the short term. It will hurt the country in the long term. It will weaken the rule of law that protects everyone. And ultimately, it will leave the American people less protected from corruption, from abuse of power, and from the kind of manipulation that turns democracy into autocracy, one compromised institution at a time.
I would be happy to sit down with you regarding any threat to any federal judge in this country. We take threats very seriously. I will set a meeting with you, with Director Serralta of the U.S. Marshals, and I will be there. And we will talk about any threats on federal judges,
including
who
orchestration.
threatened them or who orchestrated them.
Bingo. Thank you.